But he came back to Etowah County, to the town of Gadsden, and began to practice law. Now, one thing he had done while he was in Australia as a cowboy is he had taken a couple pieces of wood, and he had carved on those pieces of wood a plaque of the Ten Commandments. And after practicing law in Etowah County for a few years, he became the district attorney or county prosecutor. He was then appointed to a judgeship and was a circuit or county judge. As he served in that position, one of the first things he did is saw that the courthouse was rather sparse of decorations, and so he took that Ten Commandments plaque that he had carved. It was these two pieces of wood put together with another wood background, and put them on the wall. And that seemed to be just fine until a few years later, when a group called the Alabama Free Thought Association raised a challenge and demanded that that plaque be removed. Now, it's interesting, they call themselves Free Thought Organization. I say that's interesting because it seems that they want to think freely, but they don't seem very interested in granting that same freedom to other people. And they said, we see that plaque on the wall, we are offended by it, and we demand that it be removed. Now, my question about the case at that point is, where in the Constitution do I read that I have a right to never be offended? That is the purpose of free speech. We see all kinds of speech at various times that we disagree with. Speech that makes us angry sometimes. That's just part and parcel of living in a free society. Saw a fellow one time had a bumper sticker that simply said, "I think, therefore I don't listen to Rush Limbaugh." Well, I respect his right to have that bumper sticker. I have some on my car that he probably is offended by. At least I hope so. The point I am making through all of this is the whole claim of the ACLU in this area has no real basis. Nothing in the Constitution says that we have a right to never be exposed to anything that we don't like. I'm going to mention another interesting case, and I know I'm doing a few rabbit trails here, but I think all of this ties in together. The Foundation for Moral Law is involved in a case down in Utah right now. Now, the Utah Highway Patrol Association has a practice that when a trooper is killed in the line of duty, they will put up a 12-foot steel cross by the side of the road where he died, assuming the family wants him to. And on the cross, they will have the symbol of the State Highway Patrol, the name of the patrolman, his dates of birth and death, and maybe a few other details like this. This has been going on for, I don't recall exactly how many years, and seemed to be fine until the American Atheists Incorporated decided to file a lawsuit. They said, we might have to drive by that cross, and we might see it, and we would be traumatized by it. Therefore, you have to take it down. Well, the federal district court ruled in favor of the highway patrol and in favor of the cross. It's been appealed to the Circuit Court of Appeals, and we are optimistic that the Circuit Court will affirm the trial court and say the crosses can remain. And we filed a friend of the court brief in the case, along with the Alliance Defense Fund and several other organizations. There are other groups that have filed in the case on our side that you wouldn't really associate with a Christian perspective necessarily. The American Legion, several police officer associations have all joined in briefs supporting our side. But anyway, this idea that you have a right never to be offended by something you see seems to apply only to those who are not Christians. As far as Christians are concerned, you can offend them whenever you want to, and that doesn't matter. It seems to be that a double standard is being applied. Anyway, so in that case, first of all, it went to federal court, and the federal judge dismissed it, said that the American Atheists or the American Free Thought Association had no standing or no stake in the outcome. At that point, they found a few individuals who'd been plaintiffs in Judge Moore's court that agreed to raise it, and they filed this time in the state court. And in the state court, in fact, Governor Fob James joined in as a separate party, but naming Moore as a defendant, but also saying that we want the commandments to remain there. And Governor James simply was saying that we think this needs to be decided, and if it's constitutional to have the Ten Commandments there, then he should be permitted to continue and not harassed like this. And if they can't be kept there, then we probably ought to remove them before we get in further trouble. But in the meantime, of course, he's saying we think it's constitutional, and we're filing it in state court because we think it belongs in state court. This is an Alabama problem. It should be resolved by the Alabama courts. The federal courts have no business telling the Alabama courts what they can and cannot use in Alabama courtrooms. Well, that case eventually was dismissed, again saying that it was not a properly drawn case with true parties with adverse interests. It was in a sense a victory because the Ten Commandments were allowed to remain and no court order was in existence that said otherwise, but it did not give us the landmark ruling that we were hoping to have. Well, in the meantime, there was a strong movement to pressure Roy Moore to run for Chief Justice of the Alabama Supreme Court, and this now is the year 2000. And I can tell you, having traveled with him, having argued with him late at night many times, having strategized with him over and over again, that the idea that he would ever become anything other than a circuit court judge in Etowah County was totally outside his imagination, totally outside his ambition. At the time this case is beginning, he had just completed the construction of a very, very nice log home out in the hill or mountain and valley country of rural Etowah County. He has several kids, very nice family, very nice wife, involved in a nice church, respected man in the community, a circuit judge, and his goal was to make that his life. But he felt that God had called him to spread the message in a way that he would not be able to do so as a circuit judge. And that being the case, in 2000, he accepted the draft, practically, to run for Chief Justice of the Alabama Supreme Court. And he never called himself the Ten Commandments judge, but that's what his friends and foes alike kept calling him. And he led the Republican ticket, was elected with about 57% of the vote, if I recall correctly. His campaign slogan was restoring the moral foundation of law. Now, I'm giving you all this detail to just show you what leads up to his placing the Ten Commandments monument in the Judicial Building. He placed it there because he believed the people of Alabama had a right to have it there. As I say, he had been referred to during the campaign as the Ten Commandments judge. His campaign slogan was restoring the moral foundation of law. He was elected because the people wanted that moral foundation restored. He hadn't said exactly what he was going to do, and I'm not sure he really decided that until the January after the election, but that he was going to do something in posting the Ten Commandments in a very public way. No one had any doubt of that, and he was elected to do precisely that. So we had several strategy sessions where we gave some ideas to what the design of this monument should be. It was to be a stone monument. When it came out, by the way, we can truly say it was a landmark, a milestone, you might say, because it weighed exactly 5,280 pounds. So we can say it was a milestone. But at the top, you had two scrolls with the Ten Commandments on them, and on each of the side, you had various statements of the courts, various statements from the Mayflower Compact, from the Declaration of Independence, and other documents. And so all this together was the moral foundation of law. It was installed in late July of 2001, brought into the Judicial Building. One of the things that took a long time, and one of the reasons that it was done after hours was simply that there was concern about whether or not the floor was going to be strong enough to support that, so we had to get some structural engineers to ensure that that could be done. It's supposed to be installed right at 6 p.m., and I'm not quite as bright as I used to be, I guess, but for those in the tape, the light bulb just went off. But anyway, the monument was several hours late getting there, so it was installed late that night. And several months later, we do have a lawsuit filed against us. It's filed by the Southern Poverty Law Center in Montgomery, Alabama. And several other groups joined with them, made a very interesting case. Now, the movie last night, how many of you were here last night and saw the movie Come What May? That movie has a lot of significance for the way this case was defended. You remember one of the issues here, you have Patrick Henry College, a college that is largely for homeschool graduates, and Michael Ferris, the president and founder of the college, has been a constitutional lawyer, head of the Homeschool Legal Defense Association, and the case that was coming before the moot court is just practice court, in other words, where you're giving arguments just to see how well you can do, not that there's a case actually being decided, but case involving a parental notification exception to Roe versus Wade. And the moral dilemma that the young man in the case and his colleague on the moot court team, who toward the end of the movie becomes his fiancée, the conflict that they're facing is, should we defend our position on what we know is right, that Roe versus Wade was wrongly decided because the unborn child is a living human being, or should we defend it on a basis that is not necessarily is right, it doesn't stand for the principles that we want, but it's more likely for the court to accept. Roe versus Wade is an abomination of a decision, and it definitely ought to be overruled. But courts are reluctant to overrule decisions. And this kid is faced with the dilemma that if we argue in court that Roe versus Wade needs to be reversed because the unborn child is a living human being and has a right to life, we'll be making the argument that is correct, our message will be heard by others, but it is very unlikely that the court is going to buy that argument because they don't like to reverse previous decisions. Or we could just simply argue that Roe versus Wade recognizes that there is a right to an abortion, but it doesn't say that you can't restrict that slightly by requiring parental notification first. And so maybe we ought to just argue that this statute ought to be upheld because it's not inconsistent with Roe versus Wade. That's not as compelling an argument to us. It isn't what we really want to say. But if we make that argument, we have a much greater chance of succeeding. Judge Moore was in a very similar dilemma. The standard test that was commonly used at that time in cases involving whether a religious display is an establishment of religion is what was called the Lemon test. Now, the Lemon test, from a case from 1972, Lemon versus Kurtzman, says that when government and religion are involved together, the religious aspect of the government's activity will be upheld as constitutional only if it passes this three-part test. First, does it have a secular purpose? Second, is its primary effect one which neither advances nor inhibits religion? And third, does it constitute excessive entanglement of government with religion? Now, we could have made a very compelling argument, I think, using that Lemon test and saying, based on that test, that the Ten Commandments do not violate the Establishment Clause. Is there a secular purpose for placing the Ten Commandments? Yes. Is that they are part of the foundation of our legal system. We need to remember our heritage. This is part of our heritage. And further, teaching people these 10 commandments is more likely to cause them to obey the commandments, more likely to make them law-abiding citizens who don't kill or steal and the like. And so, yes, there seems to be a secular purpose here. Does placing these commandments in the judicial building have the primary effect of advancing or inhibiting religion? No, I don't think so. It may have some effect. Doesn't have a primary effect. The primary effect, I think, is to simply make people aware that this is part of our legal heritage. If we're going to say it has the primary effect of advancing religion, then I'd have to ask, what religion? Christianity or Judaism? Or maybe even Islam? I actually had a reporter from, I don't remember his newspaper or what, but a reporter asked me in a rather angry tone of voice, how do you think a Jew would feel seeing those commandments there? I just said, ask Moses. Anyway, so then is there excessive entanglement? Not really. It's just placed there. Didn't cost the government any money to put it there. And they're not really doing anything except maybe dusting it off occasionally. So I think this might pass the Lemon test. We could probably win arguing on that basis. Chief Justice Moore, though, is a man of principle. And I'll tell you something about him. He is one of the few people I have met that is like Nathaniel in the Bible. Remember Nathaniel, the apostle, what Jesus said when he saw Nathaniel? Behold, an Israelite in whom there is, who is just as sincere as he can possibly be. And I hear people regularly saying that, oh, he was just out to build himself a political career out of this or get famous out of it. My answer to that is, you have every right to disagree with his stand. But if you say he's not sincere, you don't know him, and I do. Anyway, he insisted, no, I didn't put these 10 commandments here to simply tell people about our history. I didn't put them there to let them know something about the moral foundation of our legal system. I put them there because I believe that we, as a government and as a people, have a duty to acknowledge God as our ruler. And he is our ruler. And as the case went to trial, that seemed to be the chief issue that Judge Myron Thompson, a federal judge, was concerned about. Does the state have a right to acknowledge God? And Judge Thompson ruled that the 10 Commandments were unconstitutional as posted there. He said that doesn't mean that there couldn't be some public display somewhere in which they could play a part, but putting them here in the center, the centerpiece of the rotunda of the judicial building, he said that is an establishment of religion, and again didn't say what religion, and therefore it violates the First Amendment. He said, Roy Moore, in individual capacity, has a right to acknowledge God, but the state does not have a right to acknowledge God. Well, I think George Washington would be very surprised to hear that. George Washington, in his Thanksgiving proclamation of, I believe it was 1789, wrote, whereas it is the duty of nations to acknowledge God and to invoke his blessings. Abraham Lincoln likewise would be surprised at this. When he issued a Thanksgiving proclamation in 1863, he declared, whereas it is the duty of nations as well as of men to acknowledge God. In other words, if Judge Thompson was right, then George Washington was wrong and Abraham Lincoln was wrong. And maybe Thompson understands the Constitution better than Washington did, but I doubt it. Washington chaired the Constitutional Convention, and he was president when the First Amendment was adopted. Myron Thompson wasn't even a delegate to the convention. Obviously, he wasn't born until nearly 200 years later, so he has a legitimate excuse. The point I am making is Chief Justice Moore could have defended this on grounds that would be more likely to have succeeded, but he refused to use those grounds. Instead, he stood on a similar principle to what the young man in the abortion case last night in the movie was standing on, and refused to compromise. And one of the results of that was an adverse decision, just like it was for that young man. You know, there's one other aspect of this case that I'd like to tell you before we get in more to the interposition aspect of this, and this is that the federal court building is located only about 4 or 5 blocks away from the Alabama Judicial Building. And that's where the trial took place. Now, interestingly, in front of this brand new federal building, it's a magnificent building, but in front of it, there is a sculpture. And the sculpture is of the Greek goddess Themis, the goddess of law and justice in Greek mythology. It seemed to us that this was a very good picture of the nature of these two systems. Over here, you have the federal system with its pagan goddess in front of it. 6 blocks away, you have the state judicial building of the state of Alabama with the 10 Commandments monument in it. And we raised this issue time and again at every level in this case. Why is it permissible for the federal court to have a statue of Themis erected on government funds in front of its building, but it is wrong for the state of Alabama to have the 10 Commandments, even though the government expended no funds at all to place those? And none of the courts that heard this case even addressed that question. After the federal judge ruled against Chief Justice Moore on the case, it was appealed to the 11th Circuit. The 11th Circuit affirmed. It was then appealed to the Supreme Court. The Supreme Court denied certiorari, that is, they refused to hear the case. And one thing you need to remember, when you see a case of a denial of certiorari, and you'll hear that from time to time, usually in Monday evening news, because it's usually on Monday morning that the Supreme Court decisions of the week are released and announced, but you'll hear that the court affirms the right of such and such. And when you look at it, you find they simply refused to hear the case. If you see that statement, the court denied certiorari, that means they declined to hear the case. Doesn't mean that they necessarily agreed with what the lower court had decided. But they decided this is not one of the few cases we're going to hear this year. Understand that the Supreme Court has cases coming before it well in excess of 10,000 per year. They can do justice to hear probably between 100 and 200 a year. If they start trying to hear more, they'll either be having sloppy and less well-reasoned, less well-researched decisions, or else, if they're going to hear a lot more than that, the decisions will in fact be written by unelected, unchosen staff people. And all of them are unelected up there, and that isn't really what justice ought to be either. And so 98% of cases that come before the Supreme Court are denied a hearing. And if they've decided these 150 cases are the ones we're going to hear for this year, they might look at a case like Chief Justice Moore's and they might say, well, that's an issue involving the Establishment Clause of the First Amendment. We're already hearing 3 Establishment Clause cases this year, this one involving government aid to private schools, and this one involving a prayer before a legislature, and that better be as many Establishment Clause cases as we're going to consider this time. Or they might have other reasons. Maybe they just want to see what more state Supreme Courts or federal district courts do before they hear it. But at any rate, the Supreme Court refused to hear the case. And so it came back down to Judge Myron Thompson, and Judge Thompson then issued an order that the monument had to be removed by a certain date. Now, as that date approached, it was pretty exciting in Alabama. It was central news all over the place. Is Chief Justice Moore going to remove the monument, or is he going to refuse? Well, he refused. He refused because he believed he had a duty to refuse. And his stand here was not solely on the basis of the Ten Commandments being the moral foundation of law. It was not just on the basis that the state has a right to have this kind of monument in its judicial building. It was also based on the argument that this is beyond the jurisdiction of the federal courts. The federal court has, first of all, no authority to start making decisions about courthouses that really are more the realm of interior decorators than judges, as Justice Scalia once said. And furthermore, they have no right telling the Alabama Supreme Court how they are to decorate their judicial building. Now, there were those who said that if Chief Justice Moore felt that strongly about it, his duty was to resign as Chief Justice, and then he could engage in civil disobedience. I would argue that if he had done so, he would be betraying the people of the state of Alabama who elected him. They elected him because they wanted to acknowledge God in some display similar to this. Myron Thompson hadn't just told Roy Moore that he couldn't put the Ten Commandments in the judicial building. Myron Thompson told the people of Alabama that they couldn't have it in their judicial building, and likewise the people of the other 49 states. He believed, in other words, that as Judge Moore believed, he had a duty to disobey that federal judge because in so doing, he was protecting the sovereignty of the Alabama judiciary, of the Alabama Constitution, of the Alabama government, and of the Alabama people. In doing so, he was removed from office. But God, I think, had his hand on this case. You know, if the Alabama Free Thought Association had never challenged that little plaque on the wall in his courtroom in Etowah County, that plaque would probably still be there today. But hardly anybody would have read it, or let alone had much of any idea of its significance for Western law. If that case had not come before the courts, Roy Moore would probably still be a circuit judge in Etowah County and would never have run for Chief Justice. If he had run and been elected Chief Justice and the Southern Poverty Law Center had never challenged the monument that he placed there, it would still be there today, a source of beauty to many, many people, an inspiration to many people, an irritation to a few. But not too many people would give it more than a passing glance, and not many people outside Alabama would even know it was there. If he had lost his court case and reluctantly complied, a lot of people would have been irritated that the Ten Commandments had been removed. Polls showed that between 70 and 80% of the people of Alabama supported the Ten Commandments being there. But in order for it to have the national effect that it had, and to cause people to start looking into what the Ten Commandments really are and how they really are the moral foundation of law, it was necessary that the case go the direction that it did. That he lose at all levels of the judiciary, that the spectacle of the commandments being removed from the judicial building with national media viewing it be made known to all, and that discussion and debate take place over what the role of the Ten Commandments really is. In other words, in losing, he accomplished something far greater than he would have had he won. God knows what he is doing. Now, getting back with that background to the issue of interposition. As I've said, as a lesser official, a state official, I believe he had a duty to resist the higher official, the federal judge and the federal judiciary, in defending the people of Alabama and their right to display the Ten Commandments. But let's go back to Scripture. And I'd like to give us a look here at 2 Chronicles chapter 10. And there in chapter 10, King Solomon has died. Solomon was a very wise king. He didn't always use his wisdom in a wise way, although I believe if you read the book of Ecclesiastes, that it seems clear that in his last days he came back to the truths that he had known as a young man. But he had built Jerusalem into a showplace capital that was admired throughout the Middle East at the time. And in so doing, he had imposed heavy taxes on his people, and had even imposed forced labor gangs upon people. And when he died, his son Rehoboam became king. And let's look at chapter 10 of 2 Chronicles. And Rehoboam went to Shechem, for to Shechem were all Israel come to make him king. And it came to pass when I'm going to read over a little bit here. I'm going to pass some of this, but no, I think we better get that whole thing. I'm sorry. When Jeroboam, the son of Nebat, who was in Egypt, whither he had fled from the presence of Solomon the king, heard it, that Jeroboam returned out of Egypt. Now, you're going to find that these are two individuals that the country isn't big enough to contain them both. Rehoboam, the son of Solomon, Jeroboam, whose father had been one of Solomon's main opponents during Solomon's reign, and has much of his strength in the northern kingdom. And they sent and called him. So Jeroboam and all Israel came and spake to Rehoboam, saying, and by the way, when they say all Israel here, it probably refers to what we know in Scripture as the congregation of Israel, that is the House of Representatives, the collection of elders and judges from the 12 tribes who gather together in a sort of parliament. When we speak about Solomon or Rehoboam addressing all Israel, well, Israel had a population of about 4 million at the time. And I don't think that Rehoboam had a PA system that was capable of addressing a crowd that size. But Jeroboam and all Israel came and spake to Rehoboam, saying, Thy father made our yoke grievous. Now therefore ease thou somewhat the grievous servitude of thy father and his heavy yoke that he put upon us, and we will serve thee. And he said unto them, Come again unto me after 3 days. And the people departed. In other words, the elders here from the 12 tribes are interposing on behalf of their people. And they're saying, Your father imposed awfully heavy taxes, and we're asking for tax relief. We're also asking that you end this forced labor. And so Rehoboam then turned to the older advisors, the ones who had advised Solomon before, and asked, What should I do? And they said, Well, taxes really were pretty heavy under Solomon, and the people do have some legitimate gripes about that. We think you ought to give them some tax relief, and if you do that, we think you will immediately become a very popular king. Well, he thought about that a bit and turned to the younger advisors, and they said, Give them an inch, and they'll take a mile. Just don't let those people push you around, and show your authority. And he said, You're right. And when they came back, he said to the people, My little finger is thicker than my father's loins. Where he has chastised you with whips, I will chastise you with scorpions. 300% tax increase. Effective retroactively. Well, you see what happened. The representatives of the northern kingdom said, What have we to do with the house of David? To your tents, O Israel. And the northern tribes withdrew. That's a clear act of interposition. Now, the problem we have when we talk about this is, does this mean that God approved what was being done? After all, the northern kingdom fell into apostasy pretty quickly after they separated. But we also read in chapter 10 and 11 that King Rehoboam proposed to gather an army and go up and subdue the 10 northern tribes. Whether he could have done it or not is hard to say, but that he was met by a prophet of God. And the prophet of God told him, "Go not up against the men of the north, for this thing is of God." In other words, in some way, this interposition practiced by the 10 northern tribes and by their elders was done with God's approval. That's a clear example of interposition as we see it in Scripture. We see medieval theory developing on the issue of interposition. Thomas Aquinas, in his Summa Theologica and his other works, probably the most brilliant theologian of the later Middle Ages, probably the most influential theologian of all as far as Roman Catholicism is concerned. If you include Protestantism, you'd probably say Augustine is more influential because Catholics and Protestants both respected Augustine. But Aquinas talks about interposition and speaks about, this is a strong term, tyrannicide. That's not killing a dinosaur. Tyrannicide, killing a tyrant. And he said, a king can become a tyrant, and if he becomes a tyrant, he is an illegitimate ruler. Now, he can become a tyrant, Aquinas says, in either of two ways. One way he can become a tyrant is by usurping the throne, taking the throne unlawfully when he has no right to it. The other way he can become a tyrant is to become king lawfully and rightfully, and then use his power in illegitimate ways and imposing things that he has no right to impose. Either way, he is a tyrant, and if you're a tyrant, well, the season on tyrants for tyrannicide is 365 days out of the year. In other words, he's fair game for tyrannicide if he's a tyrant. But then Aquinas goes on to say that that doesn't necessarily mean that the right to kill a tyrant is a right that ought to be exercised. Because he said, first of all, if you try to kill the tyrant and you fail, he'll just become more tyrannical than ever. And secondly, if you try to kill the tyrant and you succeed, then those who come into power after that may be very concerned that the same thing is going to happen to them, so they become worse tyrants than the previous tyrant. And so he said, rather than killing the tyrant by an uprising of the people, it is best that he be disposed of by lawful means, and speaks about the duly constituted lesser authorities that have the right and duty to depose him. Well, that's Aquinas' thought, and I'm just giving that because it capsulizes the thought of many theologians in the Middle Ages that talk about this concept of interposition. Now, there's something else here that I think we need to see how it's done in practice. And to understand the concept of limited government, I think we need to go back to an incident that occurred during the time of Christ. 9 AD, there was a battle, one of the 2 or 3 most decisive battles in the history of Europe. Anybody ever heard of the Battle of Teutoburg Forest? It's a battle in North Germany. In fact, if you go up to Minnesota, you'll see a little town there called New Ulm, a very strong German Lutheran community. And on a hilltop there, you will see a statue of what looks like a Viking. There's a big pavilion with this huge statue over it of a man with a winged helmet and holding a sword upward to the sky like this. They call that man Hermann the German, or Hermann the Liberator, or by his Latin name, Arminius. And you can see where Arminius is just a Latinized form of Hermann. But Hermann the Liberator was a German chieftain who gathered the tribes of northern Germany together, the Angles and the Saxons and others, to resist Roman conquest. And they, in a pitched battle, massacred 3 Roman legions, drove the remnants of them back across the Rhine River. And the significance of this battle is from that point on, northern Germany and Scandinavia were forever free of the influence of Roman law. And they continued under the old Anglo-Saxon or Teutonic common law, a law that emphasized limited government and individual rights. I'm mentioning Teutoburg Forest because this September is the 2000th anniversary of the Battle of Teutoburg Forest. And I'm afraid you're probably going to find that outside of New Ulm, Minnesota, people probably won't even know that it's taking place, with a few exceptions. But as you see, the Anglo-Saxon laws, as the Anglos and the Saxons bring them to England and deplace the Celts who were ruling England at the time. In fact, it was called Britain then, and after the Angles and the Saxons took it over, it became known as Angleland or England, and they established this decentralized system of government. They had rulers, that is, like justices of the peace, over every 10 families, and over every 50 families, over every 100 families. And then they had an earl who was over every shire, consisting of every 1,000 families. The earl had an assistant called the reeve. His duty was to enforce law and order and to carry out the orders of the earl, and he would be known then as the shire reeve. Say that word quickly enough times and you'll be saying what? Sheriff. That's where the term sheriff comes from. But England is based on this decentralized system of common law, the Anglo-Saxon law that governed England from the time of the Anglo-Saxon conquest around 500 AD up until 1066. And as the English became Christianized, we find King Alfred the Great, the only king in English history ever to be known as the Great, who sets out the first written code of laws that was to govern all England. It's called the Book of Dooms, and he begins it with a recitation of the 10 Commandments. Again, seeing the 10 Commandments as the moral foundation of law. But 1066 is a watershed year in English history. What happened in 1066? Anyone recall? William the Conqueror and the Battle of Hastings. If I had time, I'd go through a detailed analysis of the battle from a military standpoint, but let's simply say that William, who had some blood relations that could give him some claim to the throne, although probably not the strongest, is facing Harold of England, who has been chosen by the Wittang Gemot, or that is, the Anglo-Saxon Parliament, to be the new king. In the meantime, another Harold, Harold Hardrada of Norway, who was also a blood relative here, comes in and attacks from the north. And so you have the two Harolds at war with each other, and King Harold of England defeats King Harold Hardruler, or Hardrada, and no sooner does he defeat him, but he is given word that William the Conqueror has landed on the shore to the south. That's where Harold probably made his fatal mistake. His army was decimated from a very tough battle over the last several days, and those that were left were in many cases wounded, and a battle of that nature takes so much out of you that they needed several weeks probably to recuperate to their full strength. Harold should have just waited and let William come to him and meanwhile gather more strength from the various shires. But instead, he decided on a forced march, 3 days' march down to the coast in the midst of heavy rain, faces William in the battle. Battle took place in one full day, and it was hard fought, and even by mid-afternoon, it wasn't at all clear who was winning. But toward the end of the day, Harold took an arrow to the throat and died of that, And so his forces pretty much gave up after that, and William was proclaimed King of England. Now, William of Normandy came out of partly Viking stock, but came out also of French stock. French being the old Franks, powerful warriors, but Charlemagne followed the old Roman law, not the Anglo-Saxon law, the old Romanized law. And you looked at the laws of many of the barbarians that were in the Roman Empire, the Visigothic Code and others, and they're basically Roman law, a very centralized system, just simply adapted a little to different places. And that's the kind of law William learned in Normandy. And so William came to England. He didn't change everything immediately. He took the old Wittgenstein Gemot and gave it a French name, Parliament, and it persists to this day. He tried to pack the courts and so on with his Norman officials and the like, but the Angles and the Saxons were still there, as were their Viking allies and their Celtic allies, and they were concerned that their rights were being violated. And so, as the Norman kings, as we call them, that is, William the Conqueror and his descendants, become increasingly tyrannical over the years, we finally come to a king by the name of John. That's in the early 1200s, and you may recall that John's older brother was Richard the Lion-Hearted, beloved by the English people, and a superb soldier and general, one of the most successful of the Crusaders, certainly. But in his 10 years as King of England, he was in England less than 6 months. And needless to say, let a lot of things go to pot. John was indeed a tyrant. The one thing that has to be said in John's defense is he inherited a lot of problems that were not of his making, and he didn't have his brother's ability or his brother's charisma to work things out, and so things simply got worse and more tyrannical under John. At this point comes a constitutional hero. How many of you ever heard of Stephen Langdon? Several of you have. Who was Stephen Langdon? He was in the church. He was the Archbishop of Canterbury, meaning the highest religious official in the country of England at the time. And he came from the area of Lincolnshire, which was a Viking area of northern England, very possibly came out of Viking stock. But anyway, when he saw the things John was doing, he gathered the barons and the bishops together, instructed them in the doctrine of interposition. He then assisted in the drafting of the Magna Carta, or possibly drafted it himself, we're not sure. He then took a man named Robert Fitzwalter and gave him the commission title of Marshal of the Army of God and Holy Church. Together, they all came to Runnymede, met King John at Runnymede, presented to him the Magna Carta, and basically said, you sign, or you're going to be looking for a job. And the last we checked in the want ads, there weren't a whole lot of King wanted ads available, and we aren't going to give you good recommendations. Well, John signed, and there's a lot more to that story, but the Magna Carta, if you look at it, is not the far-reaching, visionary declaration of unheard of rights that many people seem to think it is. Rather, the Magna Carta is really a very conservative, reactionary document. It is reasserting the ancient, God-given rights of Englishmen against the usurpations of a Norman king. An act of interposition in the practice. Meanwhile, next century comes, and up in areas north of England, you have the Scots, and of course the Scots are always looking for some kind of trouble, it seems. That's why I like them so much. But there you have a man that all of you have heard of, those of you who have watched Braveheart. You have a man, William Wallace. And William Wallace is seeking freedom for his people. And Wallace declares, when he's called a traitor, I never swore any oath of allegiance to England. He, of course, is captured by the English, and put on trial and executed in a horrible way. And of course, in the Scots' view, he is probably their greatest hero. To the English, he was sort of like Osama bin Laden, nothing but a terrorist. And King Edward, if you remember King Edward from the movie, King Edward is, if you're a Scot or your knowledge is limited to Braveheart, well, he is the devil incarnate. But if you're English, you probably see him as one of England's greater kings. And he was working for the good of England, at least as he saw it. But after Wallace was executed, shortly thereafter we have that great battle of Bannockburn, where Robert the Bruce, I believe with Templar support, defeats the English and drives them back and proclaims Scottish independence. And then very shortly after that, we see the Scottish Declaration of Independence. It's called the Declaration of Arbroath, 1320, in Arbroath Abbey. Robert the Bruce had gathered the church officials and the Scottish nobles together. They drafted this document as a declaration to the world that we are independent. They begin by talking about how we Scots originated in Scythia, that's near the Black Sea, and that's one of the reasons that St. Andrew is the patron saint of Scotland and why the Scottish flag has the St. Andrew's cross on it, because Andrew, the apostle, had gone to the Black Sea, administered to the Scythians. Talk about how we left that area, we went through the Mediterranean, went around the Strait of Gibraltar, we dwelt briefly in Spain, and then we came here to Scotland. All of which they're trying to say, look, we aren't just declaring independence from England, we were never under England. We never had anything to do with them, and they never had any claim for us at all. And they close that declaration by saying, for so long as but 100 of us remain alive, never will we under any conditions be brought under English rule. It is in truth not for glory nor riches nor honors that we are fighting, but for freedom, for that alone which no honest man gives up, but with life itself. Interposition, again, taking place in practice. We can go on, we could read Vindicae contra Tyrannos by Junius Brutus in the 1500s. We can look at the Glorious Revolution, which we certainly should look at. Remember the Glorious Revolution where King James II is deposed, another act of interposition. But in the meantime, we've had a struggle in England. And the struggle throughout the 1600s has been between the Puritan-controlled Parliament and the Anglican-controlled monarchy. And James I and James II, and then, James I and Charles I, and then Charles II, and then James II, believed in, according to the history books, the divine right of kings. But if that's all there was to it, I would agree with them, because I believe that government is of God, as I assume you do as well. But the Puritans in Parliament likewise believed in the divine right of kings, but they believed in God's governmental authority in a different way. The king argued that God is the source of all authority. He delegates authority to the king. The king then delegates authority to these lower officials, the shire officials and the like, and they in turn rule over the people. The Puritans argued that God is the source of all governmental authority, but he delegates the authority to govern to the people. They in turn establish the lesser magistrates, and they in turn establish the king. He is under them. And since they are over him, they have the right to, and the duty to stand against him when he is wrong. And that's why you see King Charles I in 1640 being placed on trial for treason. And Charles was in many ways a good man. I think his stand was wrong, but he refused to defend against this charge because To defend would be to acknowledge that the Parliament had the authority to try him. And he said, me committing treason against you? No, you're committing treason against me. God gave me the authority over England, and you are traitors against me. Well, the Puritans won, probably more because they had more strength than because they won the arguments exactly. And Charles II was, no, I was right the first time, Charles I was executed. And then after the monarchy is restored, after Cromwell, we have Charles II, who might have learned a few things from what happened to his father and is more moderate. But then comes James II, who is much more royalist, and so the Parliament deposed him in a bloodless revolution, and he is forced to flee to France. But here again, we see this concept of interposition. And by the way, I might add that the Charleses and the Jameses, the Stuart Kings, were Scots by background, and that's why they often had a lot of support out of the Scots, even though theologically and politically their views were very different. And then in the 1740s, when a descendant of James II, Bonnie Prince Charles, returns to Scotland to lead the Scots into battle and wins several very remarkable victories, then he makes his fatal mistake kind of like Harold did. At this point, Bonnie Prince Charlie was 3 days' march from London, and London was largely undefended. George II had a lot of his troops in Germany at the time, and he could have come in and taken London with not much difficulty, but the Scottish chieftains dug in their heels. Basically, they said, Charlie, we didn't bring you over here to be king of England. We brought you over here to be king of Scotland. We do not want you to rule England. And so he had to withdraw. From there on, the battle started to go against him. That was his big moment, and he missed it. And the Scots were subjected by George II and his German troops, many of them subject to very brutal forms of execution. Thousands upon thousands of them had to flee. And when they fled, mostly they fled to America. And 1 generation later, we see Scotland's revenge against England in the American War for Independence, which was referred to by many as the Presbyterian Rebellion, or as Horace Walpole, the Prime Minister of England, said, Cousin America has run off with a Presbyterian parson, referring to John Witherspoon, or it could have been many others as well. But the Declaration of Independence itself is the ultimate form of interposition. Now, there have been attempts to try to resolve this short of armed conflict at first. On October 14th of 1774, the Continental Congress met for the first time, and they issued a resolution declaring that the good people of the several colonies, justly alarmed at these arbitrary proceedings of Parliament and administration, have severally elected, constituted, and appointed deputies to meet and sit in General Congress in order to obtain such establishment as that their religion, laws, and liberties may not be subverted. And then, of course, after the olive branch petition fails, after this, we see the ultimate act of interposition, the Declaration of Independence. And notice what Jefferson relies on in the Declaration. First, he says we are entitled to independence by the laws of nature and of nature's God. He goes on to set forth the fundamental truths upon which the nation is established, that all men are evolved but not evolved, created equal, that they are endowed not by their government with certain negotiable privileges, but by their creator with certain inalienable rights, that to secure these rights, governments are instituted among men, not to grant these rights, to secure them, deriving their just powers from the consent of the king, no, the consent of the governed, and that whenever government becomes injurious of these ends, it is the right of the people to abolish that government and form new governments more suited to preserving those ends. Very much along the same lines as what Thomas Aquinas was saying. Jefferson says that Experience and history have both shown that people are likely to put up with some minor abridgments of their rights rather than go through a full revolution or take arms. But he said, but when there has been a long train of abuses clearly showing an unmistakable direction toward tyranny, it is their right, it is their duty to resist. Ultimate act of interposition, then, the American War for Independence. Well, I think what I will do, I will close at this time, and when I'm speaking this afternoon, my topic is actually going to be the federal tyranny, the tyranny of the federal judiciary, judicial supremacy, and what can be done about it. I'll be talking specifically about Article 3, Section 2, and the power to limit the court's appellate jurisdiction, but also I'm going to talk about other checks, some in the Constitution, some implied, that we have for resisting abusive federal power. So I hope to see you again this afternoon.